And also to give kudos to you for navigating all this. I know it's not been an easy transition. That rightly or wrongly, the MLS was an efficient system, and so you're having to move from an efficient system to one that is more focused on having to interact with clients and actually have these discussions. And I'm not saying that's not a bad thing at all, but I do, for those of you who miss the MLS and how easy it was, that is understandable, because now you guys are having to provide that framework. You're having to go and do it from scratch, right? So hopefully, as you get more used to it, as the forms themselves also improve, the hope is that eventually we will also get to an efficient system, but also one that's good for the consumer and also good for you guys to interact with as well. So let's talk about the changes that happened in January. So what we had in October was a new buyer agency agreement, new exclusive buyer agency agreement, as long as and as well as a property touring agreement, right? So in January, what came out that was new was the exclusive right to sell listing agreement and non-exclusive buyer agency agreement. Okay. So let me share my screen and bring those up and then talk through them. I'm going to talk through what was adopted a couple weeks ago in January, but we're also going to talk about what I hope and anticipate will be changes that will come in July, so that I can hopefully anticipate some of your questions. Okay. So let's start with the new listing agreement that's here on the screen. Okay. So we got services provided, we got term of agreement. These are things that are generally in the other form, things that are in the old form that were maybe, made simpler, or, that there hasn't been a lot of questions about in the hotline since it came out in January. I'm not going to spend a lot of time on. If you have questions, of course, you'll be able to put those into the chat. There's Ms. Ross will help you with that, and she's accommodating. I can't see any of you, or whatever. I'm sort of flying blind here, so for all I know, I look ridiculous, and you can't see anything on my screen. So until somebody like yells at me that I'm doing something completely wrong, that I'm just gonna like keep going and pretend everything's okay. All right. So these two here, services provided used to be a whole list of things in the old listing agreement. It's just been condensed, to be simpler. The most important thing being that your client has to cooperate with you. And that's probably the most common hotline call I get as far as sellers, being in potential breach of a listing agreement. It's almost always, if there's not been a closing yet, it's almost always that they're not cooperating. They are being difficult. They are denying access to the property. They are not communicating with you, especially toward the end of a transaction, things like that. Your client has a duty to cooperate with you, and if they don't, then they do it in a material kind of way, then they could potentially be in breach of this agreement. And mind you, as an attorney, I've litigated the standard forms, in court plenty of times, and they've always done very well. So when I was proposing drafts to the forms committee to look at, that was kind of one of the aspects to the old forms I really wanted to make sure was continuing the new forms, that if you guys have a client who is in a breach of the contract one way or another, that you're going to have a document that you can rely on to have some legal remedies. Okay. Sorry. So that's paragraph 1 and 2. Make sure those are not too different than the old one. Number 3 here, you see you got the property description, which is, obviously an old, but you have a tick mark here for additional parcels. Now, hopefully, this is not guaranteed, but hopefully there will be also an additional parcels checkbox for the offer to purchase contract coming up this July. So the new listing agreement will match the offer to purchase the contract. The important thing to remember, though, is that property is a defined term. You see these little quotations right here? That's around that. That means it's like, in legal parlance, that means it's a defined term. That means everything that's described in this paragraph 3 is going to be part of the property. So if you got multiple parcels, but you're only specifying, one listing price, down here in paragraph 5, it's better be for all the parcels. If you got a transaction where you got multiple parcels, multiple prices, you're being paid multiple things, then there's 2 ways you can fix that. One, you can do a custom addendum to this, or you can do separate listing agreements and then do a custom addendum to those, depending on how it whatever the client wants to do and you're in agreement with. So just understand that. But the auction forms library has always had an option for multiple parcels, and so it's never really made sense to me that it wasn't already in the residential forms. So I suggested that we try and bring that over and make it work to accommodate in the residential context. I mean, especially if you got like an additional sliver next to a home or something like that. That's technically a separate parcel, but really should be part of the larger tract. Okay. Down here we have fixtures. There's been some small changes to these bullets, but otherwise they're substantially the same. The offer to purchase and contract will be changed to reflect this list, so that going just that they'll be in harmony. But as far as like the current harmony between this paragraph and the offer to purchase, they are substantially the same. Just some of the bullet points are moved around a little bit. So in July, these two sections should match exactly. And then going forward, there'll probably be some more small changes to this, but it won't be till after this cycle wraps up. We're hoping to wrap up this next cycle in the next week or two. So we said that last year, and then we ended up having to come back and do a bunch of stuff for the settlement. So I'm not expecting that this year, but I can never like completely rule it out. So all right, so moving through fixtures, and mind you, fixtures. Oh, by the way, there's a little typo here. I did get a couple phone calls about this. This will be fixed in the next draft. Actually, it might be already updated in zip forms as fixed because it's a typo. In any event, just understand that fixtures, I just had a hotline phone call already on this today. All fixtures are included in the transaction. These bullet points, not all of them are even fixtures. Garage door openers, like right here, not a fixture, right? The little thing you hold in your hand, just not. The garage door opener is a fixture, but obviously the garage door opener itself doesn't do much without the fob, right? So the fobs are included as part of that. And actually, this garage door openers, it's interesting. It doesn't say fob, but I've always understood it to mean the actual clicky button thing. In any event, there are other things in here that are not explicitly fixtures in the property, but all fixtures are included. And in the offer to purchase a contract, it's actually two different parts. It's 2A, which says all fixtures, and then 2B, which is this bulleted list. Understand there's both. Okay. And so if your client wants to remove something that's a fixture, which means it satisfies the total circumstances test, there's actually a Q&A on this on the website. It has to do with gyms, like home gyms. So, but if you go into the Q&A section of the website, then you can type in fixtures in that little search box there at the top and it'll bring it up. In any event, make sure your seller knows that there's two different ways to go about creating a fixture on the property. There's regular old traditional fixtures set by law, and then there's also the bulleted list, which some of those things are definitely not fixtures and there's personal property. Speaking of those sorts of things, make sure you're doing excluded items, but please, please, please do not forget this particular contract is an agency agreement. It is a contract between the firm and the seller. That means that anything in here is not binding on a buyer. So if you've got a seller who's putting excluded items in here, you need to make sure they get into the contract because the contract is the one that will bind the buyer and the seller to perform, right? Just make sure there's harmony on that. If your seller wants to, exclude something, especially something like solar panels, and they want, say, the buyer to assume the loan or something like that in order to do the sale, talk about that in this listing agreement. You can do it here or in the additional provisions that we'll see later. You can put it somewhere in the listing agreement, but more importantly, make sure that stuff gets into the contract. And for a loan assumption, especially, such as HVAC or solar panels, like big items like that, then you're going to want a custom addendum to the contract as to that. Okay. Listing price, this is substantially the same. Just put that in there. Marketing, you got public marketing versus office exclusive. That is the same as, substantially the same as the previous form. And, on office exclusive, I do, get clear cooperation questions. And honestly, a lot of times that's probably a better question for most MLSs because not every MLS is necessarily going to be the same on this. But any advertising outside your firm is going to trigger, clear cooperation, in my view. Just the way the rule's written, That to me makes the most sense. So if you've got a buyer that is outside your firm, and you're looking to do office exclusive, it's may likely trigger clear cooperation. So be aware of that. If you're doing office exclusive is exactly what it sounds like. It means that it's exclusively within your office. So to the extent previous buyers or things like that, you'll have to find other ways to, negotiate that transaction. And if you call the hotline, I'm not sure if the hotline information is in the chat already or not, but you can call the NC Realtors legal hotline or email us. It comes to our office here, and you either get me or my two partners, Adam and Bill, and we can help you through that and how to navigate that. There is one other way, but I won't go into it here. In any event. So public marketing, office exclusive, make those elections with your seller. You got lock boxes. You get a blurb here about marketing risks on the property. That's substantially the same as the old form. Surveillance devices. Make sure the seller, is disabling audio from the devices on the property, and I would make sure you disclose any video equipment too, so that people know where it is. It's probably best to disable all of it, but some sellers, as I'm sure most of you know, they're just not about that. The biggest thing is the audio. And it's not like a small thing either. I mean, it's technically a felony. Like we're talking about like actual criminal crimes here. So make sure your seller understands the importance of that. And there's more in a paragraph below that we'll talk about in just a minute. So I'm going to leave that for now, but there's a little blurb there as far as surveillance devices here. And then there'll be more on that later. All right. So let's talk about this section here. I'm going to start off by saying that if you have questions about this section, like I completely understand. Honestly, this section, it was meant to not not shake the boat, rock the boat, whatever, however you want to phrase it. It wasn't meant to upset things too much from the old form. It was trying to give you guys some familiarity. But honestly, with the questions that we've been getting since this form came out just a couple of weeks ago, it's really interesting that there's actually a lot of different things that probably need to go in this section. So for example, on this other line here, for right now with this form, until July rolls around, questions like, how much does your firm expect to be paid if there's a dual agency situation? Which that was actually in the interim guidelines on that. Or how much does your firm expect to be paid if there's an unrepresented buyer? These sorts of questions. You can put these on this other line or just have like like a sheet of fees and say, see attached. There's a couple different ways you can, if you have those sort of specific scenarios now that you're navigating with your firm, that's the best way to deal with it for right now, those sorts of questions. Okay. Hopefully, what I'm going to propose to the forms committee is actually that we're going to add like 3 or 4 more check boxes right here to address those directly. So you're not having to, try to put it all on this line or see attached, things of that nature. So these were things that honestly just weren't part of the old, contemplations in the old form because they weren't necessary. But now that you guys are having to navigate this new territory, they are. And so it's one of those things where, we appreciate your feedback and input very, very much. If you have feedback or input on the forums, you can send it to the legal hotline, or Leah, I don't know if you can find this or not, but there's a forms change email address that goes to Lee too, that could be out there for people to send suggestions to. So we always take your feedback and input and then use it to make the forms better. So that was based on several phone calls that we got. So hopefully that'll be part of the new form in July. In the meantime, when it comes to your firm's fee, that's, and you have those specific different scenarios, then you can put those out there that way. All right. And that was also just kind of one of the things that, the old form had every single possible scenario, out there in several sections. And so this form in particular is meant to give you like good bones. But if you want to attach a custom addendum as a firm, that's perfectly fine. Like you can always attach a custom addendum. And furthermore, since you as a firm are a party to this contract, then it's probably good to get lawyer input on it, but you don't have to. Like you're not drafting, it's not unauthorized practice of law. You're not drafting for a buyer and seller, other people, right? And you're not a party. Your firm is a party. So just understand that that's an option when it comes to the agency agreements in a way where you can tailor them. And this is meant to give you the good bones from the previous form, but also give you a little bit more leeway to do, those sorts of, custom things. But to the extent that it makes your guys' lives easier, we're definitely open to feedback and editing, even things to a new form. So just so you guys know and understand that. All right. So the big change, though, from the old form to this form is that in the old form, it was assumed because of the way the MLS rules were written at the time, it was assumed that the firm just gets the listing firm gets a total amount and then shares part of that with the cooperating agent, right? That's just not how things work now. And because cooperative compensation is not facilitated that way through the MLS now. It can be facilitated all different ways, and firms are doing it all different ways depending on your market. Depending on your market, you may not see much change at all. Like listing firms may be doing it substantially the same, or you might be seeing things where it's being done completely different. So I've gotten phone calls on every part of the spectrum. It's been sort of interesting to me to see how that's sort of played out. But what this is meant to do in this section in the new form is this firm's fee is what your firm is getting paid. That's it. All right. It doesn't assume any part of cooperative compensation. Cooperative compensation is here. Okay. So and it starts with this checkbox here. Either the seller does or does not agree to offer cooperative compensation. Okay, so that's the first checkbox. It's a threshold issue. You got to decide that first with your seller, and you can explain them, pros and cons, and then make a decision about how you're going to approach that. Okay, so that's where you start. And then you got firm's fee here, and you got the question of cooperative compensation. Then this top line, this top box, okay? This is what you would check. If the firm is just going to do everything, you got a seller who's like, listen, man, I just want you to sell my house. Like, honestly, I don't want any, I don't want to do anything. How much is it going to cost? I want you to go do it, right? You all know and have probably encountered clients like that, okay? That's fine. That's what this first box is for. The firm is authorized, not mandated. Okay. If you look in the old form and if you look in this form, I've said this many times that you're authorized to offer a certain amount. I'm authorized to walk out of this office right now, but it may not be a good idea. I mean, it make for a short presentation, which might make some of you pretty happy, honestly. But I'm authorized to do it. There's nothing, nobody's holding me hostage here. But I'm not mandated. I'm not being forced to leave. Authorized is exactly that. Authorized is permission. It is not mandatory. It never has been. It's because of the way things used to work. There was a way that things tended to flow. But honestly, if you just look at the language in the form, it's always been an authorization. And that's still true now. Okay. That's not changed between old form and new form. That's the same. So firm is authorized to offer, this amount to a cooperating agent, such as a seller sub-agent or a buyer's agent. Okay. So you can check that, and that's how that would work. The difference between the first box and the second box is seller may offer. Now, the reason you want this as a listing firm is because you want authorization from your seller. If you're going to put in, some kind of advertisement out there up to a certain amount, seller, is willing to offer cooperative compensation with a qualified offer or whatever, something along those lines, then you want your seller to have told you to do that, right? And you want that in writing. So what I would say is that this section here, the seller's going to be more involved with that. They're giving you authorization to put the feelers out there, right? But that's it. After that, they're going to be brought in more on how much is it, what are they asking for, and then may ultimately just sign and be obligated on the Form 220 themselves. Okay. So that's really just difference between the first two lines. Firm is signing the 220 or seller's offer is signing the 220. Okay. And that's it's meant, this whole section is meant to reflect how you guys are operating. Whether you're using 220 or something similar, it's meant to reflect that change, the fact that cooperative compensation is simply not always wrapped into whatever the firm is being paid. At least in a significant number of transactions, that's not how it is. But you can, formulate this however your firm's policy is. You can formulate it however you like. And finally, the third box, which was also in the old form, you can offer cooperative compensation as attached in the firm's policy, and just do it that way too. Now, these little romanettes follow the first two check boxes. Okay. And basically what they say is that if the firm's offering it and signing the 220, then the seller has to pay that money at closing. Okay. In addition to the firm's fee. So this amount up here, again, is just going to be your firm's part, whatever your firm is receiving for its services. Romanet 1 here says that if there's cooperative compensation, that'll be added to firm's fee at closing and in pay. The second Romanet, seller's just going to do it directly, right? It's not going to go through listing firm. The listing firm's not going to have any sort of coordination with it, although probably most of it's going to be on the closing attorney anyway. But that's what Romanet 2 is talking about, is that the seller's going to do that because you need them to be on the hook, because you don't want to be putting advertisement out there for the seller and then them turn around being like, yeah, I don't really feel like doing that. Right? You guys got no things to worry about. If a seller tries playing games with you on that when he's giving you authorization up here, then Romanet 2 really explains to the seller, yeah, no, you agreed you were going to do that. And we've already talked about this. We've talked about this. Line D here, I would say this: if you're doing a whole like different amounts for different things up here in firm's fee, then probably on this line here, just put C above. I am not sure this section D here will survive till July. It may be eliminated. That'll be up to the forms committee what they decide to do with it. But if you're just doing like, just a percent for the firm's fee right here, and then you're just doing one sort of percent for cooperative compensation, then yeah, you just do whatever the total amount is right here and put it down so that the seller can see easily what's going on. Okay. Is that really going to, if this is a difficult line for you in your firm, you just put C above, it's okay. Or, I'm not sure I put NA. I think C above is a little bit more, uh, I think it gives a clear indication, but you can deal with this line how you see fit, or you can cross it out too. That's perfectly fine too. On the forest policy, the NC Realtors forest policy permits you to do strikeouts and write things in as necessary. The thing you cannot do under the forms policy is get yourself a handy dandy little PDF editor and start changing the actual pre-printed language. Don't do that. That will be something where you will get a nasty gram from my law office telling you to quit. Okay. All right. Firm's fee earned and payable and due and payable are substantially the same. Just make sure that you know the difference between the two. Your fee can be earned, but may not necessarily become due and payable. If the buyer terminates during the due diligence period, things like that, those are not the seller's fault. That's not gonna be a trigger a due and payable, right? So that's why there's a difference between when your fee is earned and when it's due and payable. All right. Protection period is also substantially the same as old form. The language on it is a little bit different, but it works substantially the same. Just make sure within 15 days you're delivering to the seller a list of names. Okay. Home warranty, whether the seller is going to offer that or not, just move through that. This is a change here in Form 101 that's different. It used to be the standard language was that the seller just would split it. Like, it didn't used to be a checkbox option. That has changed in the new form, also because you guys were asking for it as members. You didn't feel like you wanted it was a difficult conversation with the seller, or you're having to waive it or things like that. So now it's just a negotiated term. If they something your firm, if your firm, depending on how much money you're putting up front, if you want to explain that to the seller, great. Or if you want to give it as, give the seller the entire earnest money because you just feel that that's the best way to treat your client, you can do that too. But in any event, you can use it as a selling point in either direction. You either put up a bunch of money, you want the split of the earnest money fee if the buyer breaches, or you don't. It can work either way. All right, moving on down to dual agency. Now, this has generated a lot of phone calls. So let me just start with this. If this is a section that that you don't like, okay? If you've looked at the new form and you don't like how it's laid out, I just want to make it very clear that this is what the Real Estate Commission expects. Okay. This has been, we have talked to their Regulatory Affairs Committee. One of them, one of their lawyers sits on the Forms Committee to make sure that we have input from the Real Estate Commission on these things. You can go back to and look at the forms change summary from 2022 when the dual agency section in the old form was redrafted. Okay. And you can see that the whole point of that redraft in 2022 was, especially down here for designated dual agency, if the seller directs designated dual agency, that's when that language was added in, that's what you have to do. Well, think about it. If the seller is directing you to do designated dual agency, does that allow the same firm to the same agent in the firm to do dual agency? No, absolutely not. That is automatically out. The seller has directed you to do designated dual agency. That means you got two agents in the same firm with a firewall between them. Okay. That is not going to permit the same agent to represent both buyer and seller. It's furthermore not going to allow two agents in the same firm, one to represent the buyer, one to represent the seller, without a firewall, where they're set, where they are, not subject to the same, uh, same rules. Designated dual agency has special rules, and so if your client directs it, it's in direct conflict with the other forms of dual agency that are permitted. That's why this section is laid out the way that it is. And honestly, I'm going to say this as politely as possible. I understand why you might want to fill out these initial lines, like the working with real estate agents brochure, where it's kind of like a menu, where you just pick all the available things. But that's exactly how agents got disciplined a couple times in 2022 that led to the other changes. And I know this because Will Martin told me. Okay. So if you're going to disagree with that, then you're disagreeing with Will Martin. And as we all know, that is not a thing. Okay. No, I'm just kidding. Um, I used to disagree with him all the time, like little brother syndrome. And I'm not sure in the years that I was here, like I think we were together here 8 years. I'm not sure I ever won a single one. I don't know, maybe one or two. I honestly don't even remember. It was so so few times that it's hard to remember. In any event, all it is to say is that this section here is not a menu, okay? It needs to be clear from the get-go. Now, what if you look at the language for a designated dual agency, right? If you do elect for that one, then, if it's not allowed under North Carolina law, you're not going to do it. The seller's agreeing to that. So, all right, good. We're covered there. So if you got like a provisional broker and a BIC, on either side, then all right, great. You know, then we're not going to do it. And you're going to tell the seller, that that's not going to happen. Or seller authorizes firm in writing to dual agency only. Dual agency only means just regular old dual agency. Okay. So it'd be one of these two lines. And you can get that writing in an email. You could do Form 710 and actually do an amendment to this agency agreement. Um, there's easy ways you can go about this, but in any event, I could tell you, and I want you to know that I'm not just saying this out of thin air, that the Real Estate Commission expects there to be a clear election here at the time you do the agency agreement. And then if it changes later, fine. But if you're not following that, and if that's not your process as a firm, then you really need to think about your process as a firm, because that is what the Real Estate Commission expects. And if it turns out that you have a problem in a transaction later, and I've seen this happen before, where there's a mix-up between the agents or between the clients about whether designated dual agency is being practiced or not, it can definitely lead to discipline and it can lead to problems. So that is why this section has been changed to the way it is. You're going to make an election on these first two initial lines as to whether there's going to be dual agency or not. Then you pick one of these three where it's either the same agent in the firm can represent both buyer and seller, or it's two different agents doing regular old dual agency, buyer and seller, or designated dual agency. It's got to be one of those three. And if it changes, do some kind of writing to effectuate the change. Okay. There may be questions on that from you guys, but that's where I'll leave it for right now. I just wanted you to know that it wasn't, NC Realtors going out there and just you know, going crazy with the dual agency section. It was something that it was continuing to be a problem even after the 2022 redraft. So when we were redoing the agency agreements, this section was redrafted to try and help alleviate further confusion on that. Okay. Here we got the disclosures representations. I mean, this is a section in the listing agreement. It's substantially the same as the old one. So what I'll just say generally about this section is don't skip over it. This is where you are going to learn material facts about the property or potentially a red flag that there might be a material fact, and then you have a duty to investigate. So make sure you're going through all those things in detail with your client. Here we have the surveillance photographs video that I mentioned earlier, that paragraph, and things of that nature. Moving on down, this section 16, this will be edited for July, but I'm getting plenty of questions on it. This is not talking about buyer inspection costs. This contract is between firm and seller, okay? So that's why it says, unless otherwise as agreed, seller must pay for all inspection costs and other professional services related to selling the property, okay? It's because it's between firm and seller. I understand the confusion. I apologize. May have been my fault. I don't know. I mean, this had to go through forms committee and several other people. I think there was just something where I don't know. Hopefully you guys can understand and appreciate this. Sometimes even though you're like trying your best on something, if you're just thinking about something one way and not another way, then something may make perfect sense to you and not to somebody else. So I if this has been a confusing section for you, I do apologize. I will go ahead and take the blame. I don't know if it's totally my fault or not, but that's either way, it's fine. I will definitely recommend to forms committee that it get cleared up for July to make it clear that if the seller is ordering the costs, the seller's ordering like a pre-inspection, or here's where this really comes from, just so you guys know. I've gotten, it's been a handful, but whenever it comes up, it's bad. Okay. I've got a handful of phone calls over the time I've been on the hotline where the listing firm will order a survey. Okay. They use one of their people and they're like, ah, yeah, I got somebody. They'll get out there, do a survey, especially, over the last couple of years, it seems like it's hard to even get one of these guys to go out there in a short time period, right? So the listing firm trying to take care of their clients gets a surveyor out there. And then the seller's like, I don't feel like paying for that. I'm not paying for it. Okay. This is meant to address that because in that scenario, you're talking about a substantial amount of money, depending on the size of the property. I mean, even if it's small, you're still talking about a decent chunk of money. Okay. That's what this is meant to address. If the seller incurs costs as part of the listing, they got to pay them. This will be edited to make that even more clear. But for right now, it's in the guidelines. If you have any concerns about that, it's definitely in there. And by virtue, just as a legal matter of who this contract is between, it's not going to bind the seller to pay for any buyer costs. Okay. So, all right. And I think here's the additional terms section we talked about earlier. You know, and just so you guys know, there's this little blurb right here. This agreement may be terminated or modified by a written document signed by all the parties. This is meant to simplify potential terminations. If you have one, you can still use Form 720 to terminate an agency relationship if you want. And in the event of termination, firm may require reimbursement of fees, costs, and expenses. There's actually a blank for that in Form 720. So if you need to point this out to a client because it's just not working out, then this will you know give be able to show them that hey, we're entitled to ask for this. They don't have to agree, but at least there's some language there that says, hey, this may be a possibility. All right. So that's it for Standard Form 101, and kind of the questions we've been getting at about it so far over the last couple of weeks, and a preview of things to come that will hopefully make this form just better, even better than what it is. Otherwise, I hope that it's been, a big improvement for you guys going through listings simply because if nothing else, it's half the length and That way you're not having to explain as many things. Hopefully it's making those conversations with your seller a little bit easier. And, as I said, feel free to give us input if it's not. All right. So let's move on to the exclusive buyer agency agreement. As a reminder, this came out in October. So let's look at the changes that were adopted in January for October. So here there used to be a blurb that talked all about, how you could amend a buyer agency agreement. So there's been plenty of questions of why was that removed? I want to say it was December, the plaintiff's lawyers in the Missouri case where the lawsuit came from that resulted in the settlement and everything else that I talked about, those lawyers filed a brief in the court down there talking about their position as to amending a buyer agency agreement, which to me it did not make a lot of sense. If you're going to say, that, you know, uh, that compensation is fully negotiable, right here, then, having going out and filing a brief in court saying that you can't amend a buyer agency agreement to get additional compensation, it was a difficult thing for me in my mind to wrap around, and I'm sure, you for you guys, it probably would be too. So, in any event, the form itself cannot lend itself to inviting you guys to violate the settlement. The settlement is something that absolved all of you that are watching this right now. If you're a realtor and you practice during the appropriate time range, you were a potential defendant in that lawsuit. Okay. And so that is why it is important for you to be a member, to comply with the settlement, to continue to take advantage of the fact that that case was settled so that you didn't have to actually deal with it. Okay. And I understand it may seem like far away or whatever, but at the time, especially when all the copycat suits were being filed after the jury verdict in October 2 years ago, I mean, it was a real thing. It was a real thing where you may have, depending on where you're at, your firm or whatever, you could have been named as a defendant or your firm. Okay. So for me, as a legal matter, complying with the settlement, while, I understand it's been a change and been something that's hard to make an adjustment to, I do believe it is important. In any event, as far as amending a buyer agency agreement, if you're going to take less compensation, so moving up here for the fee for services, this needs to be a specific amount. That was true under the license law prior to the settlement. Okay. This was never supposed to be a range. So if you've been filling it out that way, then it just wasn't in compliance with the license law. And it was a pretty common mistake. I used to talk to agents about it all the time, even before the settlement. So this amount here is supposed to be a specific amount for the firm's fee. So if it's more than what you've specified up here, then what the plaintiffs' lawyers in Missouri would expect, and what NAR's guidance has said, they have a do's and don'ts FAQ on this. And if you email the hotline, I can email it to you, or you can just like Google NAR amending buyer agency agreements, it'll come right up. But in any event, their position is that if you're going to amend a buyer agency agreement to get more compensation, that amendment itself has to comply with the settlement. That means you're offering additional services. It means you are doing something extra. There's some benefit to your client, something that would make it in compliance with the settlement. Okay. That's what NAR's guidance has said. So when you're talking about potentially getting additional compensation in addition to whatever is in this section up here, that's really what they're talking about. Okay. So the pretty common question that's come up once this language got removed was, well, what about builder or seller bonuses? We don't know where they're coming from, whatever. So when I did the original video talking about these changes that's on YouTube, I hadn't really like digested that question, and I apologize. It's just I do my best, but I can't anticipate every single thing that's going to come out and happen. If I could, I would, I promise. But I'm just anyway. I'm just trying to get better at it. I guess I'll just say it that way. In any event, builder seller bonuses. What I would do, and what I've been recommending to people in the hotline is, on this other specific amount line, put a specific amount for a seller or a builder bonus if offered by seller or builder. And then that way it's making it clear that, if offered by seller or builder or something like that, that makes it clear the buyer's not agreeing. That's offered, if it's offered by the seller or builder It's a specific amount. I think it would comply with MLS rules and the settlement and with the license law. I think that'd be okay. And for July, I'm gonna make a recommendation to Forms Committee that we put something in this section on that specifically. For now, in the interim, go ahead and use the other specific amount line to outline those sorts of things. And if you know builders in your area in particular that do this, just put it in there, or you can make it more generic or general, just something like that. If it's in here from the beginning, then you're not having to amend the buyer agency agreement to try and get additional compensation. I can tell you that I will be recommending to the Forms Committee that they eliminate Form 770. Like those of you who are using Form 770, you probably don't need to be using it. That was something that when the settlement first came out, it was a form that was already in the library that could fit a specific purpose. But given the events of December, I just don't see how it's a form that helps you guys right now. So what I would say is that if it's a form that you're using, then you may want to consider not using it anymore. Um, and like I said, I don't know what the Forms Committee is going to do with it, but it may well be that that'll be eliminated come July. If they decide to keep it, great. Then we'll issue guidance on that. But for right now, it's just something where I'm not really sure how it fits in. Okay. All right. So let's see. You can see we already covered this in some detail, but you can see here that the lines for the dual agency part of 201 used to only have two initial lines. Now it reflects what's in the listing agreement, so it's got five, just to make the designation a little bit easier. All right, so that's it for the exclusive buyer agency agreement. There was a couple of changes made to the property showing agreement. Again, this was a form that was adopted brand new in October. Some changes, based on this change up here on that same legal brief I mentioned earlier. That's where this change came from. This is not, I wouldn't consider this as a legal matter binding, but to help sort of bridge the gap between what they're saying, in the case of Missouri, the plaintiff's lawyers there, uh, just give an outline of what you expect your compensation to be if you end up making an offer. You got to have some kind of written buyer agreement to get in the door with a buyer. This, I don't think it'll be binding on a later exclusive buyer agency agreement, but I would try to be as accurate as possible, just as a matter of trying to keep the settlement terms. Okay. And then moving on down here, we have some language about, just the standard language about the amount, format, rate of real estate compensation is not fixed by law, but fully negotiable. And then a little blurb about dual agency here in case it comes up. I think technically speaking, when we first addressed this form, to me, I just I'm not sure it really occurred to anybody whether it really triggered the dual agency, disclosure in the license law, those rules. But as we were digesting the form after October, to me, it seemed like perhaps the license law would require some sort of disclosure about dual agency. So now you have that here. Again, it's something that it's just a license law, thing to make sure that the form is in compliance with the license law. Finally, we have the non-exclusive buyer agency agreement. Some firms use this quite a bit, and non-exclusive buyer agency agreement it operates just like it sounds. Your buyer could have any number of these. They're your client, but they're not exclusively with you like they would be in Form 201. The biggest change from the old non-exclusive buyer agency agreement to this one is that now there's an option for whether the buyer will or will not be responsible for the firm's fee. In the old non-exclusive buyer agency agreement, that was not a thing. Like the buyer simply was not responsible under any terms. In this new environment that you guys are having to exist in, that may not make sense. It may not be that, even though it's a non-exclusive agency relationship, you still expect the buyer to pay something for your services. So have that conversation and just know that that's a big change from the old form to the new form. Otherwise, you could see a lot of this mirrors what we've already covered in both in the listing agreement and the exclusive buyer agency agreement. All right. I am going to go down here and see if I can see the chat and then answer some of your questions. All right. First question we have here. What about the part about the seller can relist after your listing ends and the protection period ends immediately for the listing agent? So yeah, let me go to the protection period. This was a really interesting part about this new form for me because as I said, the protection period actually isn't different here than it used to be in the old form. I've been talking to people on the hotline for a long time, and yeah, I've always had to tell agents that if the seller, even though there's a protection period, you give the names, then and your protection period is good for any number of days, then if the seller signs another valid listing agreement down here with another firm, then the protection period is cut off. So that's not a change from the old form to the new form. There's not necessarily a rule on this. I guess in my mind, it always there's a difficult there's difficult waters to navigate here because on the one hand, up here under the license law, again, you've got to have a term of your agreement, right? Your agreement has to end at some point. Okay, that's required. So at some point, your agency is required, but you've also, taken action and done things where you potentially you should be paid. It shouldn't be that suddenly the agency agreement expires and then the seller can just get all these names of these buyers and go out and do that. So the protection period is really meant to address a seller trying to abuse your relationship. If the seller's going to turn around and pay another listing firm, to then, relist the property, I don't know. There's not one right way to solve this, and it may well be that there will be changes to that eventually, especially given the new environment you guys are operating in. That is way, way, way beyond my pay grade. I don't make decisions on that. If they bring it to me, then I will, do my best to draft something that reflects what they want, what the forms committee wants. But what I would say is, that's how it's made sense to me, at least, as an attorney. But for you guys, I understand, especially if you've listed the property, let's say you've listed it for years, I mean, it's something where you had a year-long, agency agreement, and then you got it for another year, couldn't get anything done, but you had all these prospects. Yeah, I think it's unfortunate and it stinks, but at the same time, I'm not really sure how to navigate what's fair for the listing firm and what's fair for the client who's going to turn around and list another with another firm, and also under the code of ethics, and the license law as far as your expiration of your agency agreement. Because if you think about it, the protection period is a sort of an exception for you to be paid for listing services, even though you don't have a listing agreement anymore. Your agency's done. So anyway, all this to say, hopefully that's not too nerdy. I explain that more if I need to, but that yes, the protection period is cut off if there another listing agreement is signed by the seller, but there's no change between the old form and the new form on that. All right. Question. Dual agency line never said initial only one line before. So I'm a dual agent because I have a buyer and seller that are okay with that. Then another agent at my firm can't be designated only representing the buyer because that line is an initial because it only says initial one. I guess that's true. It never said initial only one line, but as I explained, the way that designated dual agency works, it just would automatically kick in that way. If your client only wants designated dual agency, then that's all you can really do unless they tell you otherwise, just because the way the license law works. I think before it was implied, it's just now the form says initial only one line to try and help agents understand the risk that is there. So if you're so if you've got a conflict between a buyer and a seller as to designated dual agency, I don't know, you'd have to work it out somehow. But you can't be in a position if you're and think about it. I mean, this I get that. I think this underscores uh, changing the initial lines to the way that they are now. Because if you've got a seller who's only agreed and directed you to practice designated dual agency, if you've got a seller who's directed you to do designated dual agency, right? And a buyer who's agreed to dual agency but not designated, then to me, you don't have harmony there and you can't do it. Hopefully, it's an easy fix because the buyer agreeing to designated dual agency helps them. So hopefully you'll be able to convince them to just say, hey, let's go ahead and amend our dual agency section, or you direct me to do designated dual agency in an email or something like that, so that you got some kind of writing to show that. And then the buyer can just move forward and do it that way. But yeah, no, there's got to be harmony when it comes to a buyer and seller and dual agency. And the answer is no on the next question. If your seller's okay with both dual and designated, then what I would start with is regular old dual. Like that's what a lot of firms do. It's probably more common. A lot of firms don't do designated dual agency. I would talk to your BIC about what your default position should be if you have a seller that's okay with either dual or designated, but you're going to pick one because that's what the real estate commission expects. Fee for services. Would you check both boxes for the percent of sales price and the box for other specific amount? Oh. So when it comes to the seller builder bonus, so it's talking about, let me go over to the form here. So yeah, if you got a seller builder bonus, the buyer agrees to pay firm, check all that apply. So yeah, if you got more than one thing here, check all that apply. They're all going to be part of the fee for services. So if you've got a buyer agency agreement that was signed before you heard me talk about this today, but you haven't made an offer yet, or you're still looking at houses, I think under the settlement, it's fair game to amend your buyer agency agreement now. So if you want to go out and amend your buyer agency agreement to add some language about seller builder bonus, I think that'd be fine to do now. What you cannot do, and what has always been my understanding of the settlement, is you can't just make your fee for being a buyer agent match whatever the seller or builder is offering. So that you cannot do. You can't go figure out how much they're offering and then match your agency agreement to that. Okay. But yeah, I think if you got an existing agency agreement right now and that language is not in there and you want to change it, fine. Um, what do we have compensation in the buyer's agreement and we actually agree to less later? Yeah, if it's less, then the way it used to be is that buyers would kind of just waive it. But think about it. If you filled out your buyer agency agreement correctly, prior to all these changes, then you had a specific amount in there, and then the MLS would come along, and you may get less. And nobody said anything about it. Nobody did anything about it. Essentially, the buyer agent just waived it, and I think that's still true now. So if there's less compensation, that's agreed to as cooperative compensation with the seller, then as a buyer agent, you could waive it, or you can actually amend your agency agreement with Form 710 and change the compensation amount. All right, looks like there's no more questions. Really appreciate you guys tuning in. Of course, if you think of a question later or have any follow-up or if I didn't quite get your answer your question correctly this time around, feel free to reach out to the legal hotline and we'll help you out. Hopefully, I won't be talking to you guys again until after July. I, I I am crossing my fingers. I'm trying to as much as possible work as hard as I can, and a lot of people on the forms committee as well as other staff and realtors are working hard to make sure that all these things work as well as they can for you in your practice. So hopefully that means that we'll have things good enough for now until July rolls around, and then we'll go from there. Until next time, hope you guys have a great afternoon.